Our top story at this hour, the Constitutional Court has refused to declare the Administrative Adjudication of Road Traffic Offences Act and its Amendment Act unconstitutional. This is a blow to the organisation Undoing Tax Abuse, which had sought to have both declared unconstitutional and invalid. OUTA had argued that through the legislation, the national government was trying to take the control that the issuing of traffic violations from provinces and municipalities had. It also said that the legislation had unlawfully interfering in the exclusive executive and legislative competence of the local and provincial governments. It's bringing Wayne Duvenage, the CEO of the organisation Undoing Tax Abuse. Perhaps unpack what this judgment really means going forward. Wayne, good afternoon. Thank you for your time with us here on the SABC.
Hi, good afternoon. Thanks for the opportunity.
Perhaps in lieu of what's transpired, we can contextualize this conversation. Help us understand what the AARTO Act and the AARTO Amendment Act entailed and why you sought to have it declared unconstitutional.
Well, it's quite complex, but firstly, it's not a blow to us. We do many cases. Losing one is, we accept it. We're not aggrieved. Sure. And life goes on. We don't stop doing our work. But let's just put this into context. I think government's making a grave mistake that it did on e-tolls simply by thinking that if it legislates something, it works. The scheme, there were two elements to it. The one is the workability or the unworkability. We call it the impracticality of it. And there was a constitutional issue, which we won in the High Court, but the Constitutional Court felt otherwise. That doesn't mean to say that every municipality is going to accept and participate in the scheme. And we know that many aren't, because it is going to usurp their powers. And the national competence doesn't, in the collection of these revenues, which takes a big chunk of it away from municipalities, that they're going to be aggrieved by that and they're going to challenge that themselves. So the constitutionality might arise in other forms of how those municipalities and metros protect their own revenues from the hands of the RTIA, which is an empire-building situation of making a lot of money at a national level when those revenues should be accruing to local government. That aside, this scheme is about how do you make it work. And when you need an accurate NATA system, and remember, we told government the same thing on e-tolls. We said it doesn't work at just legislating and think it's all going to happen. You need competence, you need administrative efficiency, you need to be sure that NATIS is updated and accurate, you need to be sure that people get their traffic fines on time to cater and to take advantage of the discounts, and you need a reliable post office for that. Not everyone is on the internet. There's so many factors at play here. And we're not opposed to a demerit point system, a national demerit point system. This is about making things work, and we want a government that works efficiently. We had workshops. It's not just us, by the way, saying this. The AA, many freight organizations and others have raised their concerns. We had a workshop with civil society, invited the RTI to the workshop. They declined. They didn't want to come and hear about the pending challenges. So our view right now is that's fine. The Constitutional Court has said go ahead. Well, then go ahead and launch it, and let's see what happens. We don't want to sit here in 2 years' time and say we told you so. We're not here to destabilize the situation, but what we can see is grave and gross failure to administer this process going forward.
Oh, so Wayne, you've spoken about the concerns, you've spoken about how we actually make this work and the practicality of it. Perhaps for those who've tuned in, you could explore the reasons given by the court to dismiss your appeal.
Well, just that they found that there was the government, the national government has the ability, their constitutional right as well, to introduce legislation that's going to be applicable, and we're not opposed to that on a national basis. The issue really for us was how they were usurping the powers of local government. They don't believe so. So it's, this is one of those where there's going to be a different view. We believe that local government needed to come in more strongly to, as amicus or whatever, to bring this case as well. And they didn't come fast enough. Some came too late, and some now know what the ramifications are for them, but they will resist it as well. So the High Court judgment is pretty straightforward. Fortunately, we didn't get costs awarded against us, which says something. It means we didn't bring this vexatiously. We bought it in the interest of public interest, and the court acknowledged that. So we didn't lose with costs. This is not a blow to AARTO. We accept it, and life goes on for us, and we've got a lot more to do. But the AARTO matter will fail. in its current administrative processes and structure that has been set up to do.
We're also obviously trying to understand the way forward, the effect this is going to have on taxpayers, perhaps what the strict new rules mean for drivers, the demerit system for South Africa, and whether it's also adequately going to deal with the road fatalities at large. How do you weigh in on this?
Yeah, not at all. Remember, AARTO was put in place for the last 12 years in Tshwane and Joburg. It didn't change one iota of traffic infringements, of road deaths for road fatalities, accidents, nothing of that nature. So all you've got is a committee that's going to oversee objections to traffic fines that come through. If people don't get them on time, they don't qualify for the discounts, as we said. Let me put it to you in this context. Somebody can drive on your number plate, giving you fines, because it's easy to clone number plates, and this was a problem with e-tolls. So you pick up the fines, which you don't know because you don't receive them, because your notice is inaccurate, and you're not getting your post. You go and get your license renewed, and they say, sorry, you've got demerit points against you, you can't renew your license. You happen to be a sales rep, you can no longer do your job, you lose your job, you lose your livelihood. These are realities. These are the realities that will come out of this scheme and this system. Then not to talk about, let's not even go into the space of bribery where policemen know that this is the last point. If you lose this point, you're going to lose your license, and they start to leverage on that from a bribery and corruption point of view. And we know that's a challenge in this country. So again, once again, government is just failing dismally and not engaging, seriously and meaningfully with civil society to find solutions, because we've got solutions to this. Not that we don't want a demerit point system. We want what works and what's practical. Because it works in some countries like e-tolls, doesn't mean to say it's going to work here. And that's the reality here. You have this hubristic approach, this arrogant approach that says we are government and we know best. Well, let's wait and see.